Welcome to Next Gen Mentoring Forum. The Next Gen Mentoring Forum series is to empower, educate, and illuminate individuals who are already in or interested in the financial planning industry. At each forum, an expert will discuss a topic in the field of financial planning with the purpose of inspiring critical thoughts and discussions. In today's sessions, our returning guest speaker, Dr. Kathleen Rehl, will discuss the topic of how can financial planner assist clients to give it twice with the T-CRUT. My name is Dr. Chia-Li Chien. I am an assistant professor and director of financial planning program at California Lutheran University. I maintain an active financial planning practice specializing in succession program management at Value Growth Institute. It is a great honor for our expert, Dr. Kathleen Rehl, to talk about today's topic. Dr. Rehl wrote the award-winning book, Moving Forward on Your Own, a financial guidebook for widows after death of her late husband. More than 75,000 copies of this book are in circulation today. Now, Dr. Rehl owned Rehl Financial Advisors for almost 18 years before she retired to a 6-year encore career empowering widows and their advisors through her speaking, writing, doing research about widows. Her work has been featured in articles published by the New York Times, Wall Street Journal, Kipling's, CNBC, USA Today, and many others. She happily refired on her 73rd birthday in 2020. Dr. Rehl and her new husband, Chia-Li, concentrate on family, fun, focused purpose, friends, and fitness. She enjoys writing legacy poetry and stories, plus assisting nonprofits everywhere. So welcome, Dr. Rehl. So nice to have you back in our session today. I'm going to go ahead and stop sharing on my end and let you pick up the presentation on your end.
Okay, let's see if I can get this to share screen. Okay, have you got it on your end?
Yes, very good, thank you.
And I need to reduce these thumbnails. Okay, here we go. Thank you all for joining us today about a topic that's a little bit different. I think you'll find it of interest, especially if you work with charitably inclined clients. I want to begin by reading a poem that I wrote almost a year ago. It's called Not My Son. Sunny Saturday afternoon, my Android rang. Screen said police station. Hesitant, I took the call. My biracial son came on. I'm going to jail, Mom, but I didn't do it. Instant memories, almost 50 years ago. Police guns pointing at my African husband's head and mine. Wrong interracial couple profile. It wasn't us. Checking IDs, they saw we weren't suspects sought. Jumping into Mama Bear mode, hiring expensive, effective legal counsel, fighting charges. Bottom line, son's case dismissed. Made me ponder how to protect, love, provide for my son and grandson in the future when I'm gone. Other threats may linger on. Too many brothers have died or been crucified. No, not my son. Many years ago, I made my son the beneficiary of my IRA account. It seemed like a good thing to do, but I've changed my mind since then. And it was this incident that I wrote the poem about that jolted me into that particular action. Now you need to know that that IRA account that I have over many years and careers, it's resulted in a pretty substantial size. In fact, it's the largest asset that I own. And many of your clients, that may be the situation too, that most of their money is there. And my career spanned a lot of stages. Well, of course, I wasn't paid when I was a farm girl and student, but that's where I started out. And then I was a public school teacher. After that, I became a university professor. And then I was in the nonprofit sector for a dozen years. And after that, I had my own financial planning practice for almost 18 years. And then after I sold that, I went into an encore career with lots of speaking and writing and mentoring. And then I finally retired right now. Well, over all those years, and I led, I will say, a very frugal lifestyle. I'm not a big spender at all. And so I pumped away as much as I could into retirement plans, some from the university, like my 403B plan. I did IRAs. When I was into my encore career, that's when I actually set up a solo 401k plan, and I was able to put lots of money away then. So at the point that I finally refired a couple of years ago, I consolidated everything, all those different assets, and put them together, and came up with about 1.7 million in my IRA account right now. Now, if my son, and there's a ticking time bomb, which that, in my opinion, has become that ticking time bomb, because I've saved taxes as I've done the retirement plans, but eventually when the money comes out, there's going to be taxes to pay. And if my son would suddenly inherit, if I died tomorrow, if he would inherit that $1.7 million IRA, it might just be like winning the lottery for him. It could be a case of a luxury twice tasted becomes a necessity. There could be things that happen. And indeed, wise judgment sometimes is lacking with my son. When he inherited his late father's retirement plan, he was a university professor, he inherited that account, and within a year, that six-figure account was gone, totally gone. Now, you also need to know that my son's career has been spotted along the way. He's had great corporate jobs, 6 figures earning, and he's had periods where he's been unemployed totally. He's had contract employment. So it's spotted along the way. And it's my understanding that during those periods when he wasn't working, he drained money out of his existing retirement plan, which is, as you know, I mean, lots of taxes to pay on it, but that he really doesn't have any retirement savings right now. And he's 43 years old. You also need to know that he's got a disability, ADHD, diagnosed. And on top of that, he's in a difficult marriage. So you can see there are all kinds of compounding factors that make my situation kind of special. And I am going to be giving my son some money outright, but I don't want to give the bulk of that 1.7 million to him right away, because it would just be gone. You all know about the stretch IRA that went away. Well, actually, it was the law passed in 2019, so it started in 2020. We used to be able to stretch beneficiary IRA accounts out for our lifetimes. I've got an IRA that I inherited from my mom, for example, when she passed several years ago. And I just take the required minimum distribution out of that account, no more every year. And believe it or not, that it's in a balanced fund at Vanguard. Even though I keep taking the minimum out every year, that account is worth more now than it was. But folks who inherit IRAs now are going to have to take it out in 10 years. They don't have to take anything out until the 10th year if they want to, or they can take it out 1/10 every year, or however they want. But by the end of the 10 years, it has to be drained. And I just feel that that's going to be real problematic for my son. So what I've done is set up a testamentary, it'll happen at my death, Charitable Remainder Trust. And if you're familiar with charitable remainder trusts, a lot of times people set those up during their lifetime to benefit themselves. There are all kinds of advantages, but mine's the actual trust will begin at my death. However, I had to put plans in place for that right now. So I've got my document created, and I'll talk a little bit more about the document as we go along. But in that document, I named the Charitable Remainder Trust as a partial beneficiary of my IRA, because that's possible. Just like we could split it up percentages to go different places. Well, a percentage that equals $1 million is going to go into my charitable remainder trust. And then, by the way, every year I will readjust this depending on what the size of the account is, so that the percentage equals that amount. And then that charitable remainder trust starts making payments to my son, who I've named as the income beneficiary. There's what's known as an income beneficiary, and then a remainder beneficiary, which is the ultimate beneficiary, the charity. But my son starts getting income, and he's going to be getting income for 20 years. I could have set it up for any number of years, up to 20. I could have even set it up for lifetime, but in my situation, I have chosen to do it for 20 years. And then the balance goes to the nonprofit organization that I've identified after all those payments have been made over the 20 years. And by the way, the trust does exist now, and I am the trustee of it at this point. It's only at the point that I die that the charitable organization becomes the successor trustee, and it really gets going. So it's like an unfunded trust right now. All right, and to qualify for establishing a trust, it has to be set up so that the beneficiary gets a payout of 5% or more, and there needs to be 10% or more of a remainder for the nonprofit that's anticipated when you crunch the numbers. So if I've got $1 million IRA, there would have to be at least calculated $100,000 going to that charitable organization. Okay, so hang on to those numbers. This is just a snapshot of what the benefits are going to look like with my charitable remainder trust. And I'm going to show you where these numbers come from in a next slide, but just so you've got a broad brush overview. With the charitable remainder trust that I've got $1 million of my IRA going into, the before tax benefit to my son is anticipated to be $1,241,000 and something. And of course, if I would have just bequeathed it to my son outright, it would have just been that $1 million. The after-tax benefit, assuming that my son might be in a specific federal tax bracket of 32%, would really be $844,000. And if he had the no trust option, it would be $680,000. And what's left over for the nonprofit is over $1 million with the trust, and of course nothing if there was no bequest for that. Okay, so promised you that I would show you the numbers. There's a wonderful firm out there called Crescendo, and their website is actually at crescendointeractive.com, I believe. And they crunch all kinds of numbers up and down, backwards and sideways on many charitable plan gifts. And they've got one specifically for a testamentary charitable remainder unit trust, because there's no way that I could have figured out those other numbers on my own. So this is just one of the summary screens that you get in the wonderful report from Crescendo for a 1 million unit trust benefits for family and charity. And if you look down at the bottom, what I've highlighted in yellow, those are those same numbers that came from this summary table that are in this table. And I've assumed that the assumptions are on this, that it's a payout of 6% to my son. So it would give him $60,000 a year. Every year reevaluated what the amount is in that unit trust. If it had grown, then he would get more than 60,000. If it had shrunk, it would be less. And so we assumed on this one a 6.5% return, and then there were some expenditures on that. So you'll see if, like in the second column, the unit trust income payout of 6%, that's growing a little bit every year because the value of the trust is growing with our assumptions. And you look at the bottom lines on these, and that's at the bottom of this page. There's one that says the present value in 20 years, and that's 594,000. And I think my next slide shows, yes, this is another one of the charts that Crescendo creates. You can have it in flowchart. It is so donor friendly that, like, if you are working with a donor, a client of yours, the different ways that you can show people how the benefits are going to stack up for them. But you can see over on the left, the estate value, that where it says 1, it talks about saving estate taxes. And in my situation, the way the law exists right now, I would not owe estate tax. But for someone who did fit in the category where they would owe estate tax, there would be a charitable tax deduction of almost 300,000 that they would have realized. And then this shows how much the family is getting, and 6% in the unit trust and what the nonprofit winds up. It's another way of showing the same facts that were on that previous page. Yes, this is the one that if you look down near the bottom on this page, it shows line M, or M, which is line L, the present value of the remainder interest. This would be the federal estate tax deduction that they would earn. All right, so what are the advantages of a charitable remainder trust for me and for lots of other folks that you would use this? You can stretch the income payments to heirs over more than 10 years. Like I said, mine for my son is going to be 20 years. And I chose that because there really is a strong possibility that I may outlive my son, which sounds strange because I'm about 30 years older than he is, but because of his situation, I might live longer. And last week, I just celebrated my 75th birthday, and I'm going strong. And there's a little calculator out there. You may have tried it, and you answer several questions, and it says how long you're going to live. And I've done this about 3 times, and it just gets better. So I'm going to live to be 104. And like I said, I'm very healthy. And I don't know how long my son will live. And I wanted to stretch it 20 years. So if he passes, say, in 10 years after it starts, then it would just be over if I just named him for his life only. But I can do it 20 years, his life, and if he dies prematurely, it'll go to my grandson for another period of time. Of course, when my IRA goes into the trust, there's no taxes that it has to pay because it's a charitable entity. And as you saw in those tables, how it would reduce tax for my son because he's getting just this nice annual payment instead of all one lump sum, which would throw him into a much higher tax bracket. As long as the money stays inside that trust, it keeps growing tax-free. Last week, I was a participant in another webinar that was done by a local attorney for nonprofit executives and attorneys, other attorneys, and accountants and financial planners. And she talked about the fact that a lot of those folks are not using these vehicles, but they don't think about all the advantages, including all of the tax deferral. It's not paid out. So she was encouraging folks to consider it. There's some protection against creditors and others. Heirs might end up with more money than if they just got it outright. And this is not something I'm going to do, but if I decided, like say that there was some miracle, I'm going to get rid of a little bit of sun here, and things straightened out in my son's life and his marriage, and I decided that I wanted to change my plans, that trust that I've got in place right now, that it took me 11 months to get it in place, I could tear it up and say this is null and void. There's that estate tax deduction that might benefit some people, but it wouldn't benefit me. And it supports my values, because the ultimate recipient of my trust after I die, the next, which will be the next administrator of it, is a nonprofit organization that I'm directing mine for social justice efforts. And that's really important to me now during my lifetime, and it makes me feel good knowing that when I pass on, it's going to continue to do that work. What are the disadvantages? Some people might say it's more complex than an outright gift to heirs. Yeah, that's really easy. Just I give it all, especially with your IRA, just fill out that form in 5 minutes and say it goes there. But it didn't accomplish what I wanted to do. So this process from start to finish actually took me about 10 months. And there are reasons why parts of it went slowly, but it was definitely more complex. And it took a whole team. It wasn't just me by myself. And it wasn't just the nonprofit. There was also an attorney firm that was involved with it. So it takes a whole team to put together something like this. And my green bullet there says needs an attorney. You can go out and get sample documents from the IRS. And we started with some of those sample documents, but because of the things that I wanted to include in my trust, it just wasn't going to work with those sample documents. But they're a good place to begin. And there can be certain administrative costs involved with it. So because of that, it doesn't make sense to do one of these with a small amount. It has to be a fairly sizable IRA account. And I checked with a number of nonprofit organizations, just went to their website and read about it. And the least that I found, the recommendation was $250,000. Most of them are talking larger than that figure. All right, which of your clients might this be appropriate to consider? I've listed some possibilities that I have observed, and I've helped a lot in my years as a nonprofit executive. I set up lots of charitable remainder annuity trusts and charitable remainder unit trusts with clients, not in this situation that I'm in myself, and definitely way before the stretch IRAs were eliminated. But the folks that I did set these up with, they were definitely mature individuals. They were not youngsters setting these up. Had a large sized IRA account. There might be some special situations, like 3 of them that I worked with. One of them, a mother had a druggie for a son, and she did not want him to get it outright. Another one that was a remarriage of a mature couple, and there was a situation on who died first, where would the money go, and so we used a trust for that. And there are several others, but oftentimes there is a special situation that requires something different than just a boilerplate. The goal isn't to give the kids everything. I like Warren Buffett's statement about wanting the kids, to know that they're loved and appreciated, but he's not going to give everything to them. Like the idea of reducing tax, and the government does definitely wind up short because the money goes to the nonprofit organization to do the work. And wanting to have an influence after we're gone, to leave a legacy. And it really must be for charitably inclined folks. People who are looking at it just from a tax break, it's not going to work. I would have people contacting me and wanting to run the numbers, and the scenario that they wanted to do was They wanted to have a trust payout of like 15%, and they wanted to have it last the lifetime of all 7 of their children. You know, the first one would get it, and then it would be divided 6 ways and then 5 ways. Just things like this. And before I even ran the numbers, I knew that that would not work, because there had to be this 10% of the value left for the nonprofit organization for it to fly, for it to qualify. So then the people would get upset because they were all excited about the tax savings and the state tax savings, and it wasn't going to work. So they really need to be charitably inclined. This is a slide I added just this morning because I wanted to encourage you, in addition to sharing some financial ways of leaving a legacy, there are other ways that you can help your clients with legacy storytelling, stories and poems. And we were just finishing up plans for a session that we're starting up again for another nonprofit. So those are other ways, definitely, for legacy. But I really believe that I've heard it said that we're happiest when our lives have meaning and we can have a positive impact. And for me, one of those things is focused purpose, as you heard at the beginning of my retirement. But it's also important for me to leave an endowment. And so, picking up on the theme of my book, Moving Forward on Your Own, this is to establish the Moving Forward endowment. I like the idea that that's going to continue giving forever, 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 forever. That matters to me. And I told you about my birthday. Well, this is also partly the way that I can celebrate 75 years of giving and growing by putting this in place. And actually, I want to, before I end and say thank you, I want to tell you about a piece of research. I like research. I was a researcher. It was done with charitable giving. And they had professionals, financial advisors, working with 3 different groups of clients. And the groups they tried to get them similar in terms of demographics, like ages and men and women and things like that. And so they're working on their estate plans with all 3. And the first group, they had the advisor not talk about leaving a charitable gift in their estate plan at all. No mention whatsoever, just like which of your kids do you want to get what? Okay. The second group, they said, would you like to include a charitable gift in your estate plan? And the third group, they said to the people, many of our clients include charitable giving in their estate plans to benefit those organizations that are near and dear to them. Would you like to do the same thing? Well, can you guess what the outcome was? Which of those 3 groups made more charitable gifts in their estate plans? Well, if you guess group 3, you're right. The first group, where it was not mentioned at all, or the second group, just asking them kind of an open-ended question, didn't come along with the results of that third group, where they said most of our clients do this. And I was sharing this with a group of attorneys recently with a session that I did. And one of the fellows said, oh, I don't believe that's true. I ask all my clients about charitable giving, and they're really not interested. And I said, well, what is it you say to them? And this was his quote. I wrote it down so I remember it. Oh, I always ask my clients, I say, you don't want to remember charitable organizations in your will, do you? Duh. So he's just set them up for the response on that. And I also believe that as an advisor, we help to lead the way by talking about what we have done with our own plans, and that can help encourage others to do the same thing. So I'm going to close out. Thank you very much for having me do this.
I have so many questions. If you don't mind, I'm asking the questions.
Yes.
And I may end up asking you to show the slides again. I wanted to go all the way back to the Charitable Remainder Trust. I know that some of the participants may have the understanding of it, some may not. So let's just go back to the very basic. I think based on what I heard, this is obviously someone who has to be charitable inclined.
Yes.
Having this charitable remainder trust, you mentioned that the trust itself every year needs to have some money out, and then the remainder will go to the charity. So I think that the breakdown you provided was minimum 10% of the trust itself goes to the charity toward the end of that 20 years or whatever number of years that you set up.
When
And
that's
each
yeah,
year,
when that's actuarially determined.
right. So in each year, you have mentioned minimum was 5% or more. Is that correct? Would you mind to go through
No,
it?
it's the payout rate must be 5% or more
Okay.
of the value of the unit trust. So like somebody couldn't set it up so that it only, I couldn't set it up so that only 3% went to my son. I
Right.
set it, and I set the figure at 6%. So
Right.
that's 6 times a million, that's 60,000 a year that he gets.
Right.
And that 6% doesn't change. With as you know, with the unit trust, it's 6% of the value of the assets in that
Correct.
trust. With an annuity trust, which I didn't use, annuity trust, it's like the 6%, and that continues at 6% no matter what happens with the value of the trust. If it goes down or if it goes up. And I chose the unit trust. There is a potential for growth so much, but if I can't predict what the stock market's going to do. And so I want based on the value of that rather than $60,000 a year, which there had years ago, like if you look at the history of some of these things, when some of these annuity trusts were set up in the heyday when interest rates were so incredibly high, and people set these at payout rates that were like at 10%. For a couple of years that lasted fine, and then we had downward trends, and so the value of the trust shrunk. Right. And for some of those, it just went away. I mean, there wasn't anything left at the end for the nonprofit organization.
So I guess it's important to understand the difference between the unit trust and annuity trust. And depending upon the purpose of the client, and in your case, the unit trust is the best option for the beneficiary in this case.
Yeah, I wanted to balance what was going to benefit my son and what would benefit the nonprofit organization.
Right. Okay, good. So then now we got that charitable remainder trust all clear away in terms of technical part of it. The other questions that I have is obviously having the attorney firm set up this and having the trustee after you are gone in place. There's obviously a threshold that is ideal for someone who wants to set this up. If someone who has only $100,000 IRA, this is probably not necessarily the route to go. So is there a threshold that you would recommend?
Yes, that $250,000. People who have less than that, who want to do, they might consider charitable gift annuity. And that just requires a simple contract between the individual and the organization. It would be a testamentary charitable gift annuity at that individual's death. And the gift annuity would be for one individual. If they wanted to have, I had one client that they set up 15 testamentary charitable gift annuities. They didn't have children, but they had nieces and nephews. They had 15 of them. And so they set up a charitable gift annuity for each of them, each of the nieces and nephews, that'll go for their lifetime. And it was a percentage of an IRA account that I've forgotten. Maybe it was a couple $100,000. So they were going to be small gift annuities, but that nonprofit organization was fine in setting it up. So, and that couple is still alive. So it hasn't started paying nieces and nephews yet, but I would say for smaller than $250,000, I would look at testamentary charitable gift annuities.
Okay, so that sounds great. So in terms of now we know the threshold, the size of the trust that's most viable to move forward. One of the questions that I have is obviously the money sitting in a trust needs to be invested. So do you then have a company manage those accounts? Or does
Right.
the trustee manage that? How does it actually work?
Yes. You have great questions. Right
Thank you.
now, it's an unfunded trust.
Right.
There's nothing in it. When I die, the money goes into it. The successor trustee will be this nonprofit organization, and it's their responsibility to pick who the manager is. And they have one that they have used forever. It's actually State Street Bank. And that's another reason that I wanted to go with this nonprofit organization, because State Street Bank, which is headquartered in Boston, I believe, they have a whole division that just deals with philanthropy gifts like this and others. They know what they're doing. And so I feel very comfortable about that. I did not, in setting this up, I hit a lot of barriers. There were some places it looked like it would work out to be done locally, but then I realized, well, who was going to be managing it, and the fee schedules, and it would really eat into it. But State Street Bank is not that way. It's, part of their mission is to help philanthropy, and so their fees and expenses are much lower. So I dug into that because I wanted. Now, is that who's going to be managing it when I die at 104? I don't know, but right now it looks very good.
So one of the things to look into is that other than working with the charities that you incline to have the money go into, but also look at who actually is going to be managing that, because it does matter. If they do a good job with a low fee, that amount could potentially continue to grow, and that's great for the charity and also great for the beneficiaries at the same time.
Yes. And because I wanted the successor trustee to be the charitable organization, because like they're not charging fees against it. Had I just set it up with, I could have named a financial advisor to be this, or advisor's firm to be the successor trustee. And there might be firms that would love to do that, but then they would certainly be charging fees against it. The nonprofit organization is not going to. So it took me actually 3 months to sort all of that out, because it looked like locally there was the possibility of having it done. I thought, oh, that's really going to be cool because I'll be connected locally. But then when I saw like how the successor trustee was going to work out and the management was going to work out, that's not what I wanted.
And so be sure to check out the successor trustee and the management behind it, because it does make a big difference in terms of the fee and how they manage.
Yes.
I wanted to turn into a different type of question. This, the stretch IRA, which oftentimes that we are referring to, after the 2020 expiration day, often we're referring to as non-spouse. So in your case, your son is a non-spouse. If they don't do anything, if you don't do anything, he has to take it out in 10 years, and regardless how he actually take it out. But for spouse, they can still stretch. So my question would be that in this idea, will a spouse actually be a good candidate as well? Because, and I'll share a little story here. Yeah. And the reason I wanted to share this was I had a conversation with my mom last year. She told me some horrible stories about my dad's siblings. So my dad has 2 elder brothers who, before their wives died, they were joined to the hip. They love each other. They're just very wonderful, loving couples. And both of these uncles of mine, if you will, that have sworn in front of everyone that if their spouse died first, they will not do anything. They will just be alone for the rest of their life. All right. So what happened? I know where you're going. I know. So what happened was that my mom actually witnessed the 2 brothers almost simultaneously that their wives passed away. Within 3 months period of time, somebody glued to the next to them out of nowhere. And so my mom was really concerned. She wanted to make sure her portion of the money is taken care of. So I have to actually walk her through of how to contact the attorney. Now, my mom lives in Taiwan. She doesn't live here. So it's not something I could just take her. And my mom is very traditional. She doesn't want my dad to know that she's setting this up. So she's keeping everything so secretive for the purpose of she doesn't want someone else get the money. She'd rather have her children or somebody or charity to have it. So my question is, the spouse in this case, and as you were talking about this, I'm thinking about, well, I probably want to do the same, even though my IRA is going to go to my husband. But, just in case if somebody flew to right next to him in 3 months or even less, right? I wanted to make sure that he gets enough annual basis, right? He, likely that you can stretch, but in this case, it's a spouse. So could you talk about if a spouse situation versus non-spouse, will that matter in this case?
Oh, yes. You can see I'm just stomping at the bit to tell. I had a case where a couple, like, they remarried. And they're married later in life. I think they were about 50 years old. She was 50, he was 40 when they remarried. He had never been married. He was a postdoc Ph.D. nerd. And the wife actually had been married many times. I think it was about 5 times. Okay, they had a little farmette, and he loved to work on stuff, and they were clients of mine. And he said, probably what's going to happen is I'm going to have a tractor accident and I'm going to die in some farm accident, and she will still be alive. And he lived a frugal lifestyle, and he had lots of money in his retirement account too. And he said, what's going to happen is within a year, she's going to find some muscle-bound guy at the gym, and she's going to remarry him.
And then just name him Fabio. I always love Fabio.
Fabio. Okay, Fabio. And I will have given her all of my IRA assets. But then Fabio is going to outlive her, and he will wind up getting everything that was mine. I don't want to do that.
Right.
So we created what they called, and I know this is not politically correct, but the husband called it the Bimbo Trust.
I love it.
That money in his IRA, and he had, this was like 20 some years ago, he had well over $1 million, which would be worth a lot more now. Should she die first? No, he dies first. That IRA, that $1 million would go into Charitable Remainder Unit Trust and pay her income for her lifetime. And after that, the proceeds were going to go to, he had 2 major universities that he attended, that he's gotten his degrees from, his church organization. By the way, somebody asked a question in the chat room about can a charitable religious organization manage these. Those are top. And I can tell you a couple of them that are really, really good. All right. So anyway, there was like 4 or 5 different organizations that would get it. And he knew that they would get it. But his wife would be taken care of all along. And she'd get that income. And you know what? She was happy about that, because she said it would give her an excuse. So when Fabio said, we should be flying to this and that and doing so and so, she said, honey, I would love to do that, but can't do it. All my money it's in trust. That's how I've got it. So it was a delightful
excellent design.
Solution.
Yeah, it's an excellent design for that.
So and that was done years before. There wasn't the stretch IRA problem and all that, but it was just to protect that money.
Right. Now, would you then talk about the religious organization that you mentioned that it would be ideal trust successors?
Yes, there are ones that I have personally worked with. My late husband was a Lutheran pastor, so I was connected strongly with Lutheran. So when California Lutheran invited me to speak, it was just like, that's nice.
Thank you.
The Evangelical Lutheran Church in America Foundation, they're very, very big. When you look at how nonprofits are rated, they're rated right up there in the top. They do wonderful things. And I created and helped donors create a lot of charitable gift annuities, charitable remainder trusts, gifts like that through the Evangelical Lutheran Church in America. The Presbyterian Foundation is excellent. They just, I mean, their record keeping, their information for donors, just their field staff that go out and visit are wonderful. My particular trust, I've done it through the Unitarian Universalist Association, which I'm a member of now. And I am just blown away by what they've done, bent over backwards to help to make this possible. They have a wonderful attorney who is a field person, and he was just really, really great. So I've had personal experiences with those three. I know there are, oh, there was another one that it was a Jewish foundation that was excellent. The large organizations will be able to do these kinds of trusts, like I'm thinking of St. Jude and the Cancer Society, big organizations like that. Your local food pantry is not going to do it, and a local congregation is not going to do it. It's going to be their umbrella organization that will have the nonprofit foundation, and there are not, you're not going to get billed for the work that they're doing with you, because they know that to get this done right, at the end there'll be the payoff for their organization. So religious organizations and very large, like health organizations, are the ones that I've had personal experiences with myself and with the donors that I've helped set up these programs.
And that's a really important point. For people doing this, you do have to have some sort of charitable incline to do this.
Yeah.
We do have a questions in the chat. Paul was asking.
One more, like some community foundations may be able to do this, but they also may be apprehensive about, because it's kind of new. And I found that be with my local community foundation. They want to get moving on it, but they don't have facilities in place yet to go there.
Okay, so thank you for that. So Paul's questions here is that the testamentary CRT is set up first as a revocable trust, then it became irrevocable after you passing. So he's just confirming, is that the case for
Yes.
your situation? Okay.
Yes, and yep.
And we have another question here is the income paid from the CRT or testamentary CRT taxable as an ordinary income, or does it able to raise people's IRMAA? I don't know what IRMAA bill is. I'm assuming that's taxable income. Can you talk a little bit about that?
It is going to be taxable income. I've read one article that said that there's the possibility of, if it's a long payout of it, that there might be at some point get into capital gain, but income rather than ordinary. But for the most part, it's ordinary income they're going to pay taxes on.
All right, so thank you so much. Now, we obviously have talked quite a bit of mostly mechanical side of it, as well as the real meaning and purpose of giving to the charity. If there's one advice that you could give to either the financial advisors or people who are interested in doing that, what would that be?
That would be what that little research study I said at the end, and to ask that question along the line of, many of our clients have included charitable organizations that are important to them in their estate plans. Would you like to do the same thing? And oh, by the way, I've done it myself, because I've left a partial beneficiary of my IRA. It was so easy to do. I just changed the beneficiary form, and they're going to get 5% of my retirement account after I pass on.
Well, thank you so much for that. And I think that the IRMAA is the Medicare higher premium.
Yes.
Yeah, that would, if the beneficiary is in receiving Medicare. All right, so thank you so much, Dr. Rehl. We are so glad to have you for our Next Gen Mentoring Forum. What an incredible, informative session. Thank you so much. And I also wanted to take time to thank California Lutheran University School of Management Financial Planning Program for sponsoring today's Next Gen Mentoring Forum. Now, California Lutheran University School of Management, we do offer MBA in financial planning that helps financial advisors pursue a leadership position or grow their financial planning practice by deploying advanced financial planning techniques with client effective communication, financial counseling, as well as practice management, streamlining that with FinTech. If you know someone or someone who might be benefit from our program, please ask them to sign up for our info session. Our next info session is going to be in February the 24th at 2 p.m. On the screen, you have the info session URL. Now, our next Gen Mentoring Forum session is actually next Tuesday, January the 25th. Please join me to interview Dominic Henderson, who is going to talk about why should you consider a career in financial planning. And thank you all, and see you at the next Gen Mentoring Forum. Be safe and be well. And thank you, Dr. Rehl, very much for today's session.
Thank you. And I just thought, if somebody wants to read a little bit more about it, if you go to my website, there's 2 articles that were published about it. One is Jonathan Clement's Hummel Dollar, and then there's another one out there too, but that'll just tell you some more about what you learned today.
I will include that into our blog site that will have this reporting as well. So thank you so much, Dr. Rehl. And thank you, everyone. Be safe and be healthy. Take care. Bye-bye.